Here we go.
Good afternoon, Judge.
I'm ready when you are, Ms. Abraham. And we're probably going to have to adjust that camera because that looks pretty low. I don't think I'm going to see most of their faces.
Richard, will you put the-
I'd go a little higher. I'd go high. I'd go
I'm
higher.
gonna get Richard over here so I can,
Higher.
he's about as tall as,
Yeah, it needs to go up another 6 inches. I'd go high. Yeah.
I cut his,
I'm used to looking up to people, but if I don't have to, I don't want to.
that better?
That's perfect. That's better. Yes. Who's up?
Mr. Manning is going to make an announcement on Brandon Harrison.
All right, Mr. Manning, let me get over to your case. CR 21-171, State versus Brandon Lee Harrison. True or not true? Mr. Harrison is in Wood County.
True, Judge. And Miss Abraham was just informing me that there may be a way for us to get the paperwork sent up to him, emailed, signed up, and him to appear via Zoom, possibly.
Okay.
So I was just made aware of that today. I'll see if I can figure something out with that, get the paperwork from the state, and then get that sent over to him.
You want to, how long do you think you want the reset for? I'm looking at October 14th or 26th.
$14th or what?
26th.
Looks like I'm here on the 14th. We could add him there.
On the 14th?
Yes, Judge.
All right, we'll set Mr. Harrison then for plea on October 14th at 1:30.
Judge, I believe that concludes my business. May be excused.
Yes, thank you, Mr. Manning. Not very loud today.
Just a temporary. This material needs to print.
Okay.
Okay, Judge. Mr. Knoll is ready on Ricky Norris.
Ricky Norris. CR 21-181, CR 21-302. Let's go ahead and arraign Mr. Norris in 302. Have you been able to review the indictment with Mr. Norris in that sexual assault of a child charge?
Judge, I haven't been able to review the indictment. I actually haven't had a chance to print one off. After we do that, I think we could still waive arraignment. He's aware of the charge. We talked about the charge actually even before it was indicted. I think the only thing that would probably still need on that is the CAC interview. My understanding, alleged victim is probably 16, but I think they still would have done a CAC interview. And obviously, we don't have the right to have one of those of our own. So we'll need to set up a time to be able to review that.
Did you say, Mr. Knoll, you are trying to print out the indictment over there?
No, I have not had the opportunity to print one out. But we are aware of what the charge is, and his name is spelled correctly, just as it is in the other case that we appeared on. He's aware of the charge and the range of punishment on that case. We'd enter a plea of not guilty.
I just want to make sure that the name is spelled correctly.
That is correct, Your Honor. He indicated it was.
All right, the court will enter Mr. Norris's plea of not guilty into the record in CR 21-302. We'll set him for pretrial. Are you available on October 26th, Mr. Knoll?
Hopefully on a beach in Hawaii, Judge.
On October 26th?
I'm sorry?
Did you say on October 26th?
No, I need to go into November. First week's fine.
How about November 9th?
Sounds good, Judge.
All right, I'll set Mr. Norris for docket call on his older case and pretrial on his newer case, November 9th at 1:30. Mr. Norris needs to understand that if he makes bail in this case, his court hearings will be at 9 in the morning at the courthouse.
This is the only other case I have on the afternoon docket is Amanda Templeton, and she is still in Henderson County, I believe.
Was she not brought over?
No, sir. Can we reset her to Thursday?
I'm here, Judge, Thursday on Parker, Ashley Parker.
Okay, we'll set Miss Templeton. Are we gonna ask the jail to make sure that she's brought over?
Yes, sir.
Okay, we'll set Miss Templeton then for docket call on Thursday, the 28th.
30th.
So I'm sorry, the 30th, Thursday, the 30th.
If that's all I have now, I'd be excused.
Yes, thank you, Mr. Knoll.
Thank you, Judge.
Okay, Judge, we're ready with Mr. Sanders' defendants. Mr. Amador?
Yeah.
Mr. Amador?
And who is this, Mr. Amador?
Yeah, Daniel Amador.
All right, CR 21-204, Mr. Amador is set for docket call, and CR 21-205 also set for docket call.
Yes, sir. And Judge, we have reached a plea bargain agreement. I would just ask if we could set it for a plea in a couple of weeks, if October 14th, if that's a good day for the court.
Is it gonna be for time?
No, for probation.
Are we gonna let him sit in the jail for a couple of weeks instead of?
Well, Judge, if there's, we're able to get all the paperwork together today. And so I didn't know if there's an earlier time when we could do the plea, that'd be fine.
I mean, I could set him for Thursday.
Judge, I may still be in jury trial then. We picked a jury yesterday in the 241st. We start evidence tomorrow. Actually, I was going to bring this to the court's attention because I have a contested suppression hearing on Thursday that I may not be able to be here for anyway. I mean, we could put him on the docket for Thursday, and then if I'm still in trial, then we can see what we need to do at that point, I guess.
Is Mr. Amador going to be doing any jail time as a condition of probation? Obviously, my concern is this: if the paperwork would have been done today, he'd be getting out of jail today.
Right.
Set 2 weeks or a month and he sits in jail. Have y'all talked about that? Do y'all have any plans? Do you have a recommendation or desire?
Judge, the state had no discussions with defense about adding those jail days as a condition.
Well, no, what I'm asking is there wasn't a condition that he was going to do more jail time
No.
before probation. So if paperwork is ready today, Mr. Amador gets out of jail today. But as is, he's not, and we're asking to set for 2 weeks or a month, and Mr. Amador stays in jail.
And Judge, if we could set it for Thursday, that'd be great.
But in all likelihood, you're not going to be here on Thursday.
I don't think so.
And Judge, I can check with Miss Abney to see if we could get that paperwork done today. Mr. Sanders and I just talked about this late yesterday afternoon, and he wasn't 100% sure that his client would be willing to accept our offer, which is why we don't have the paperwork now. But I can see if Miss Abney is able to do that. We're going to have a long docket anyways today, Judge. I mean, we can see if she can get it done if Mr. Sanders is available.
Maybe that is option A. Perhaps I suggest option B is waiver of jury trial and PR bond as option B.
State would be agreeable to that.
And that'd be fine, Judge, too.
All right, so Mr. Amador, I'll recall your case. Ms. Heisel, if Ms. Abney's not going to be able to do it, then let us know. We need to move to option B and send over the waiver of jury trial. And I'll just wait to hear from you all on which one you want to do.
Sounds good. Thank you, Judge.
That'd be great,
All right.
Judge.
All right, is this Mr. Cravey?
Yes, sure, it is.
Jason Cravey, CR 20110, motion to revoke. Go ahead, Mr. Sanders.
And Judge, on his revocation, we don't have an agreement at this time. I'd ask if we could set it on the contested hearing docket. Court has one in October.
Okay, we'll set Mr. Cravey for the contested docket on October 28th, and that'll be at 1:30. Is that all you have, Mr. Sanders?
Yes, sure, it is.
All right, we'll just wait on Mr. Amador then.
Okay.
All right, Ms. Abraham, I'm ready.
I was gonna ask a question. Do you want me to bring up Eric Massey? That was one of Mitch Adams's defendants, or do you want us just to reset?
When did we reset the other ones too?
10. Let me see, I think it's on the 10/14.
So I see here that this is a Class B criminal trespass. Does Mr. Massey have other felony cases? That's
I believe it was,
here.
Judge Winters has represented Mr. Massey a number of times, and that's why it was filed upstairs.
Mr. Woodwhy, I know the practice is on the Class B misdemeanors is to discuss with Mr. Massey whether or not, and I guess he's asked for an attorney here, but apparently he hasn't been to court and had an opportunity to see what the state's offering. I guess Mr. Adams has already been appointed, so we might be too far past that point, but what's the offer to Mr. Massey right now?
Give me a moment, Judge. Let me take a look.
Do we have anyone else? Mr. Abraham?
Mr. Smith is ready. On Mr. Bustamante.
And Judge, if I could interject really quickly, Ms. Abney is going to be able to do the paperwork on Amador. She just needs Mr. Sanders' court-appointed attorney's fees.
Okay. CR 21-9, CR 21-281, State versus James Daniel Bustamante. Mr. Bustamante set for docket call on the ag assault deadly weapon, CR 21-9, set for arraignment on the newer CR 21-281. Mr. Schmidt, have you had an opportunity to go over the indictment with your client?
Judge, Mr. Bustamante, his name spelled correctly. He understands what we've been charged with. Range of punishment, et cetera. We wait for him reading of that new indictment, enter a plea not guilty. Ask that it be set for pretrial.
All right, court will enter Mr. Bustamante's plea of not guilty into the record. CR 21-281 will set pretrial October 26th at 1:30. Court will carry the other case on docket call, same date.
Judge, also, if I may, previously we were here on a motion for bond reduction and a writ for Mr. Bustamante. I'll remind the court that the issues that we had were, at the time, Mr. Bustamante is a disabled veteran, and the court held its ruling on our request pending the outcome of an available residence for Mr. Bustamante to live once he's released. The court's concern was that he not be virtually homeless if he were to be released from custody. I've had discussions with the National VA and we've made no progress, but Mr. Bustamante has secured a residence in which he can live. It's with his sister in Keller. If the court would like additional testimony pertaining to that, we can give it. But I would like to refresh the court's memory on that issue so that the court would rule on our prior motion for a bond reduction based on that additional information.
Do you remember when our hearing was, Mr. Schmidt? I'm gonna go back and find that.
It was probably the last docket. It was in August, Judge. August 21st.
Is this, it was August 24th when we took up the competency issue?
No, that was a prior time. I think that on that date, we'd already received the results from the examination. We did not object to the finding of competency. I had a request for either PR or bond reduction. It's been a minute for me as well, and I don't have that file in front of me. But it was the last time we were in court.
Maybe July 27th. Let me go look at my docket here.
Judge, I believe it was August 24th. We are. That's right.
All right, I'm not finding anything on my docket with regards to notes on that. I see the last time we were here was July 27th, and I just indicated that we were waiting on the competency evaluation. So remind me the grounds for the motion to reduce bond. And you said that I'd indicated I was concerned that he'd be homeless and wouldn't have a place to stay or a way to get back to and from court. Is that right?
Judge, based on my recollection, we provided the court testimony through Mr. Bustamante about his ability to make bonds. In addition to that, the culmination of that was the state was concerned, Mr. Woodwhite was concerned about his residency status based on the fact that where he was living, he can no longer go. The court had asked me to check into the availability of veterans assistance for disabled veterans as far as housing is concerned, and stage a ruling pending the outcome of that question. And it was my recollection that Mr. Woodwhite's concern as well as the courts, and we couldn't object also, is whether or not Mr. Bustamante would be homeless if he were able to be released from custody. And so at this point, that's where we're at. And we basically had a bond reduction hearing in its entirety, and that was included.
Was that on a writ?
It's my recollection it was a writ. I believe it was.
Yeah, that's probably why it's not showing on my criminal side. Okay. And so you're stating now that Mr. Bustamante would have a place to go. Okay, so let me first say that the bond is set at what, 10,000? It's $10,000 on one case. Do you know what his bonds are set at?
Judge, he was on bond on the older case and then was arrested. $100,000. I believe it was set at $100,000 on the newly indicted case. And I think we filed a writ. I can't recall what the timeline was from the date of arrest until the writ was filed. He's subsequently been indicted on that case, obviously. But that was why we were in court. I think I filed a writ and a motion for bond reduction at the same time. And we could, Judge, if you want me to go back and pull those issues and send over a short blurb to you and Mr. Woodwhite to refresh the court's memory. I believe also should have a proposed order on file with the court as well.
So there was a bond forfeiture, I guess, in CR 21-9 back in July.
That's correct.
July 2nd.
Correct.
And did you provide me evidence in our hearing as to why he failed to appear?
Judge, I did. He was in custody at the time, based on this, in a different county, it's my recollection. So I was arrested in Odessa, Texas.
And that was on the issuance of an arrest warrant on the new charge?
So that's correct. That's correct.
Okay. And so, and so you're asking the court to grant him a PR bond?
Judge, I was asking that the court grant him a PR bond or reduction at the time that we had the hearing. I'm still asking that. I'm not certain the state's position at this point. Nothing has changed except for that the court was waiting to hear back on the ability to get veterans assistance for housing, which is unavailable based on his other benefits.
And so if Mr. Bustamante was to receive a bond reduction, or he was to post bail in this case, you're indicating to the court that he would go live in Keller.
That's correct. With his sister, who resides in Keller.
And would he have a way to and from court?
Yes, sir.
Okay, I'll take that under advisement and I'll look into it again and I'll respond to counsel.
Judge, if I might interject very briefly, the state trusts the court's judgment on the bond reduction. We would ask that if not even in any case, if we could have no contact pretrial release conditions added for the protection of the victim and his wife, who I believe are the defendant's mother and father, for both their residence and I believe there's a farm where this incident allegedly occurred. If we could have both of those covered, and I will have my victims assistance coordinator send those to Miss Patty, such that we can have those included in any order. That would be the state's request. And we're going to take no position on the reduction at this point.
And Judge, and that was we were coming back because that was where Mr. Bustamante resided, and he knew that he couldn't go back there. So no objection to that.
Okay, all right, I'll take a look at that as soon as I can after the docket and then I'll respond to counsel.
Thank you, Judge.
Thank you, Judge.
And we'll see y'all back on the 26th. Ms. Abraham,
Yes.
let's try to move closer. We're having a very difficult time hearing. You're gonna have to adjust the camera and all that again. Apologize, but
That okay?
we'll see. We'll see.
That is more Richard Schmidt than I was comfortable seeing at any given time.
You're welcome. That's for free. That's for free right there.
All right, are we ready on Miss Garrett?
Garrett Joslin, yes, sir. A brief announcement. Judge, Mr. Joslin said on a probable cause writ, the docket noted it as a bond reduction request. Ultimately, I've been in conversations with Ms. Heisel most of the day pertaining to our writ and some of the other issues involved with the case. At this point in time, Mrs. Heisel has provided me with the PC affidavit, as well as we've had some discussions about other relevant issues. It's my understanding that she intends to meet with the affiant officer Thursday morning. We would ask that this matter be set for a evidentiary hearing on the Thursday docket. I anticipate, assuming me and Ms. Heisel can't come to a resolution prior to that, and we're working on it, I anticipate the necessity for some testimony from several individuals. And so we would just ask that at this point that we be bumped to the Thursday docket for an opportunity to either resolve it or give everybody an opportunity to prepare to present testimony.
Okay, court will reset the hearing on the writ until Thursday afternoon at 1:30.
Judge, ultimately, I'm uncertain. I think in the past on these evidentiary dockets, the court has transported the inmates to the courtroom for those hearings. Does the court anticipate doing that on Thursday?
Well, we've kind of had a change in logistics. We've been keeping the bail clients, bail defendants in the morning, and then we've been keeping the afternoon jail clients together. So if Mr. Joslin wants to be transported over, we can probably do that, but we've been doing a lot of it through Zoom. I don't think we've had a request for a hearing yet on an evidentiary day. So what I would probably anticipate doing is bringing him over in the afternoon, but that's really going to be dependent on if we're going to have the hearing or not.
Sure, Judge. And if we could plan to have them transported in the event we solve it or come to the need to not have a hearing, then I'll notify Ms. Abraham prior to, but if we do have a hearing, I would like him present and in the courtroom if at all possible.
That'll be the plan, is to bring over the 1:30 at 1:30.
Okay. Thank you, Judge. That's all I have.
Mr. Abraham, we're going to try to make some audio adjustments over on our end, so we'll be back with you in just a moment. All right, Mr. Abraham, let's try it now.
Okay, Mr. Stockup is ready on James Stroud.
No, nothing's changed because this is, it's not coming out of here.
Are y'all
Ms.
having-
Abraham is,
Yeah, we're having difficulty hearing you at the jail. I can hear Ms. Heisel and Mr. Woodwhite, but I can't hardly hear y'all.
I have the volume up as loud as it goes on the little, you want me to go get Erin and see if she knows anything?
No, just give me a second.
Ms. Abraham, is Ms. Griffith there and available?
Yes, ma'am.
Set this up with the
Miss-
laptop.
Ms. Abraham, can you say something so I can test my audio?
Yes, sir.
See, that's not connected.
While I'm talking to you, did we decide about Eric Massey? Do you want me to bring him up?
Just give me a sec. I haven't. Let me deal with this and then we'll get to Mr. Massey.
Just talking to you, so.
Here, don't worry about it. I thought it would be better. It's not. All right, this is cause number CR 1436, State versus James Michael Stroud. And this is set for motion to revoke today's. I'm understanding that there's some kind of agreement in this case.
Your Honor, we have agreed to enter a plea of true to the motion to adjudicate and the revocation on the community supervision. And we're going open to you for punishment.
Okay, let me pull up the case so I can access the state's motion. Is this the motion that we're proceeding on, State?
Yes, Your Honor.
8/12, yes, Your Honor, I believe that's correct. 2020.
All right, Mr. Stroud, if you'll raise your right hand, so I can place you under oath.
Right hand.
Mr. Stroud, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Mr. Stroud, you appeared before the court on July 10th of 2014. You pled guilty to the first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. Court heard the evidence on that date, found that there was sufficient evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision for a period of 10 years. The court also assessed a $3,000 fine. It was during that term of your community supervision that the state of Texas has filed a motion to adjudicate and revoke your community supervision. And as you can see here through the screen display, the state has alleged in 7 counts, various ways that you have violated the conditions of your community supervision. Have you had sufficient time to review the state's motion with your attorney, Mr. Brett Stallcup?
Yes, sir.
And do you feel like you've had enough time to discuss it with him and have all your questions answered?
I believe so, yes, sir.
And are you pleased with Mr. Stallcup's representation to this point?
Yes, sir, I do.
And Mr. Stallcup, do you believe Mr. Stroud to be competent today?
Yes, Your Honor.
And does your client waive the formal reading of the state's motion?
Yes, Your Honor.
All right, so Mr. Stroud, at this time, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not true?
Those are true, Your Honor.
And Mr. Stroud, are you telling me that those counts are true because in fact they are true and you did violate your terms and conditions of community supervision?
Yes, sir, I did.
And has anybody threatened, forced, or pressured you to plead true to any of these counts today?
No, sir.
All right, the court will accept the defendant's plea of true at this time. And so, Mr. Stallcup, you indicated that that there is no plea agreement in this case, and you're going to ask the court to assess punishment, but I'm assuming that you're wanting the court to not find them to be true and to revoke him at this time. Is that correct?
That's correct, Your Honor.
All right. And are you wanting to put on evidence in this case?
I'm gonna put on the defendant, Mr. Stroud.
Okay. And are you wanting to do that today?
Yes, yes, Your Honor, if I could. I promise to be brief.
Well, and my concern is that Mr. Stroud, I believe, is entitled to the preparation of a pre-sentence investigation report under the Texas Code of Criminal Procedure. Is that something that Mr. Stroud will be waiving today?
Judge, I think I'd like to have him do a PSI on this one.
Okay. So what I'll do is I will accept the defendant's plea of true. I will not make a finding on that at this time. And we'll need to set Mr. Stroud for another hearing on this matter. And so we'll need to give the Community Supervision Department an opportunity to interview Mr. Stroud and prepare that pre-sentence investigation report. I'd like to give them at least 30 days to do so.
Perfect.
Thank you, sir.
All right.
Thank you, Your Honor.
So, Mr. Stroud, Mr. Stallcup, are you available on October 28th?
Yes.
Okay. And before we schedule it,
I just have an event that evening with Judge Kincaid, and I know we'll be done by then. Right?
so
Afternoon.
it'll be in the afternoon.
Okay.
It'd be at 1:30 that afternoon. Before I schedule that though, Mr. Stroud seems to have some physical distress about what we're doing today. You want to talk with him about that?
I've known him since the first grade. I'll be glad to tell him why we're setting for a PSI. And I think that when he hears why, he'll understand completely. I think he's been sitting in jail for a long time. He's anxious, but I want to be smart and make sure the PSI includes everything that favors him.
Yeah, I would agree, Mr. Stallcup. I think it's in his best interest for him to have a pre-sentence investigation report so that I can be equipped in rendering a decision in this case that's based on more than just what's before me at this time.
Good.
And
Okay.
Judge, while we have everybody up, state did email both Mr. Stallcup and Ms. Taberham the admonishments as well as the certification on this open plea. So,
You signed them all.
okay, okay. I just wanted to make sure that was complete before we reset this case.
No, we got it all signed and we hear you.
Okay. All right. So I will order the Van Zandt County Community Supervision and Corrections Department to prepare a pre-sentence investigation report in this case. So Mr. Stroud, one of the officers from that department, will be visiting with you at the jail. And it's very important that you cooperate with them and that you give them the information that they need to prepare that report so that I can render a just sentence in your case.
Yes, sir. Thank you, Your Honor. Appreciate it.
All right, you're welcome. We'll see you back on October 28th.
Thank you.
All right, who do we have now, Ms. Abram?
We have Daniel Hunt and Amy Bird.
All right, this is CR 12-349 State versus Amy Louise Bird on motion to revoke. Go ahead, Mr. Hunt.
Your Honor, I just found out about, I don't know, 4 or 5 days ago that I'd been appointed to this case, evidently back in 2018. I never received notice until I contacted Ms. Abraham, and she sent me a copy of the notice. I've met with Ms. Bird here today. We're just asking that this be reset to give me time to talk to, I'm not sure if it's Tyler or Hillary's case, to talk to whoever's handling that case and see if we can work something out.
Judge Tate would agree to that. I just saw your message, Mr. Hunt. It is going to be me. Looks like this MTA was filed back in 2016, which predates, I believe, all of us. So I believe there is going to be some discussion necessary.
Okay, so what I'll do, Mr. Hunt, is I'll go ahead and put it on the contested docket on October 28th. So that gives her a little more than a month to allow you to get up to speed and then for her to make a decision, for the state to make a decision if they're going to make any type of offer to Ms. Bird. And then if we don't reach a resolution, then we'll just take up the state's motion on October 28th at 1:30. Do you have any scheduling conflicts on that day?
I do not, Your Honor. That works fine.
Okay, all right, then we'll do that.
I'm gonna leave you a copy of this. Thank you, Your Honor. Maybe we'll be excused.
Yes, thank you, Mr. Hunt.
Thank you, Your Honor.
Okay, we're ready on Mario Hobson and Mr. Ashmore.
Mario. Come on up.
CR 21-123, State versus Mario Hobson, set for docket call.
Judge, we've had some more time to visit. I think it's in our client's best interest just to request a trial setting if this is our last docket call.
Okay, and what's the offer that your client's rejecting?
It's 20 TDCJ.
And what is the punishment range, Ms. Heisel or Mr. Woodward?
I think I have that, Judge. $5 to 99, Your Honor.
First degree?
First degree, Your Honor.
Yes, Judge, it's an undefined, it's 5 to 99, but it also carries the up to a $50,000 fine, but the actual time range is still 5 to 99.
Okay, so Mr. Hobson, I understand that the state's made an offer. I understand that you are rejecting that offer at this time. You understand that a rejection of the offer and asking the court to set it for a jury trial means that you will get a jury trial in this case. And that jury, while they may acquit you, they may also convict you. And if they convict you, your sentence could be the same, it could be better, it could be worse. You understand that?
Yes, sir.
And you understand that you're not, if you decide that you want to take a 20-year offer, a week before trial, the court's not going to allow you to do that.
Yes.
Okay. All right, then the court will set you for jury selection beginning November 1st. Mr. Hobson, if you make bond in this case, then you're to report to the Van Zandt County Courthouse on that date at 8:30 in the morning. And my staff will give you further instructions. If you do not make bond, then we'll just have the notices sent out to you. As soon as your case gets set for trial or occurs in the court's top 10 list of cases, then Mr. Ashmore will be notified, and then he'll be required to appear. If we're not in the top 10, then Mr. Ashmore is not going to have to appear on those dates. You understand?
Yes, sir.
Okay. All right. Thank you, Mr. Hobson. We'll be adjourned in case. Mr. Woodwhite, did you ever have a chance to look at Eric Massey to see?
Yes, Judge. Yes, Judge, I did.
Okay. And is an offer being made or has an offer been made? Obviously my concern is I don't want to have him sitting up here forever on a Class B while his attorney may be indisposed when there may be other avenues of resolving his case.
Judge, it does not appear, this case was filed, Mr. Adams was appointed, looks like 3 or 4 days after the case was filed. I don't see that Mr. Adams has ever, he's never spoken to me. I went and spoke with the attorneys that are assigned to the County Court of Law who originally had jurisdiction over this. It doesn't appear as though they've ever had any contact with him either. State would likely offer Mr. Massey something in the range of time served, considering he has been in jail for quite some time. Although I will state from previous dealings with Mr. Massey, there's likely some questions of competency that may not be a problem at this point, but have been in the past. I can't speak to that. I just, based on my prosecuting him in the past, there were some questions of competency. I don't know if they have resolved, if they're worse. I can't speak to any of that, so I don't know where Mr. Adams is on all that.
That answers my question. Man, audio is so bad today. Ms. Taberham, we'll bring Mr. Massey up.
Yes, Your Honor.
All right, and I'm ready for whoever's next.
It's going to be just a minute.
Okay.
Judge, we're ready on Brenda Martinez with Mr. Ashmore.
CR 17-240, State versus Brenda Martinez. Motion to revoke. Go ahead, Mr. Ashmore.
Judge, we're here on our first appearance. Ms. Martinez and I have had a few minutes to visit, and we appreciate that. We do have the state's motion to revoke. Ms. Martinez is 4 years into her probated sentence. And I'm just going to ask the court for a reset so I can work with the district attorney's office and see what agreements we can reach.
Next available date I have is October 14th, October 26th, or the contested docket on the 5th, on October 28th. What I would like to do is just set it for the 28th. If y'all get it worked out sooner, then we could resolve it sooner. If not, then we'll take up the motion on the 28th,
On the contested?
on the contested.
Okay, I'm good with that, Your Honor. Thank you.
All right, Ms. Martinez, we'll set you for October 28th. And that'll be at 1:30.
Okay.
Judge, we're ready on Ms. Smith. Oh.
All right, CR 19-28, State versus Stephanie Faye Smith on motion to revoke.
Judge, again, this is our first appearance. I just was recently appointed on this case. My request would be, let's reset to 10/28, allow me and the state of Texas to work on negotiations. If we're ready to go sooner, we can come back quicker. That way, we're just on the contested docket like the prior.
All right, court will set Ms. Smith in for contested hearing on October 28th.
And Ms. Courtney Shelburne is next, Your Honor.
Courtney Alexis Shelburne, CR 19-2, also on motion to revoke.
Yes, Judge.
So first setting.
Judge, same request. We just got appointed on the case recently. I do have the motion to revoke, but I do need some time to visit with the state of Texas. So again, contested docket 1:30 on the 28th of October. If we're done quicker, I'll ask court to fit us in at a time before that.
Right, court sets case for contested hearing on October 28th at 1:30.
And Judge, before I ask to be excused, my client has filed a pro se motion to reduce bond because she needs a medical visit. We'll follow that up with a proper motion with notice to the state of Texas, but just want the state and the court to be aware of the reason for that request and that the request is for a medical visit.
Okay, once that motion is filed and notice is given to the state, then we'll set it for hearing.
Okay, Judge, thank you. May we be excused?
Yes, sir. Thank you.
Yes.
Judge Martin.
Yep.
Okay, I believe that we're waiting on the paperwork for Jeff Sanders on Mr. Amador. And then we're working on, Richard's just about ready on his client, and then we have a few more.
Okay.
Judge, Mr. Smith is ready on his, on Bradley Reese.
CR 18-501, State versus Bradley, Arthur Reese. Set on the motion to revoke, Mr. Schmidt.
It is, Judge. I've been in discussions with Ms. Heisel. The state has filed an amended motion. I just got a copy of that today and I've gone over that with Mr. Reese. Obviously, we're not ready to proceed. Ms. Heisel is reviewing the case for a potential plea offer. In addition to that, we've got a couple of misdemeanor matters that I'm going to transfer up to your court so these things can run together. Judge Winters is aware of that. It's just a matter of me filing that motion. So we'll ask that this be set on until the 26th docket, I suppose.
It being a motion to revoke, what I'd rather do is set it for contested hearing on the 28th.
That's
And then
fine.
if we'll work it out. We'll do the plea that day. If not, then we'll take up the state's motion. Is that fine?
10/28.
28th at 1:30.
Okay. Thanks, Judge. That's it.
Thank you, Mr. Schmidt. Mr. Abraham, does Robert Harris have an attorney?
No, sir, he's the one that we've gone to get him. He's the one that had no financial need and he was to hire an attorney.
Okay.
So however many that he's talked to.
Okay.
Yeah, that's Robert, right?
Okay, he's in here now.
All right. CR 14-494, State versus Robert Dustin Harris.
You'll have
Mr.
to.
Harris, what do you have for me?
I wrote down the ones my family tried to get a hold of, and we're still short on the funds to hire an attorney.
How short?
So far, we got 1,500 saved up.
And who are the attorneys that your family has spoken with?
Richard Smith and Brian Smith and Mike Ed and Jeff White and no one wants Richard Smith and Brian Smith and Mike Ed are the only ones that they were ready to talk to. And they called Jeff White and no answer, and Nolan White, no answer. The Elliott Long Farm, no answer, and Wayne and I can't pronounce it.
Weiner?
Yeah, and Zachary Elliott and Mitch Adams and Deborah Beasley, no answer.
And based on the ones that did answer, how short are you?
1,000. Yeah, 1,000 on Brian Smith and about 500 on Richard Smith.
All right.
About the same.
Is your family going to be able to come up with that difference or what?
I really can't say it. Everybody's been trying to. No one's able to access my bank account because I had my card get declined or reported stolen, so it'd be a couple weeks, or at least a week before we get another one. But I tried to write down everything, so.
I understand.
And they can't. They don't know. They can't do anything with my assets or anything like that. So they're trying their best to do what they can.
Are you still wanting to hire an attorney?
Yeah. If I can get an indigent.
Ms. Abraham,
Yes, Your Honor.
do you recall where Mr. Harris fell on the indigency guidelines off the top of your head? If you don't,
Can you get into the indigent folder and then underneath indigent scan documents? I can't get on my computer out here for some reason.
I can. Indigent and then where?
Indigent scan documents or packets, I think.
I've got it.
And then just type in his name. I should have scanned it in there.
you know, I don't really think it's-
Okay, thank you.
I think, you know, it says my address on it. And, I don't know about this. Not that you-
Mr. Harris, remind me about your vehicle. Do you owe money on it or is it paid off?
It's paid off.
I show that it's worth $20,000 by your estimate.
And probably less than that. Last time I checked on the it's called website, it was like around 15, but I can't really say, but it's been a while. And I had damage done to the vehicle, so.
And your family is not able to use that as collateral to get a loan or to get cash advance?
Nah, they were afraid to do that, and they didn't want to deal with it. My brother sold his truck and tried to help out, but it wasn't only worth about $1,000, so. And basically, it's a. She said, my family said, because nobody will take it without me being present. And most loan places won't take it unless I was present there to sign the proving that it's my vehicle and everything at the loan place.
Well, that's going to be a stumbling block for you because you don't meet I mean, you've got at least $15,000 cash available to you.
1,500, I got 1,500.
No, you got 15,000. If you got a truck that's worth $15,000, you could sell it for $15,000. You might not have $15,000 cash today, but you have assets that make you not indigent, meaning that you can sell your truck.
Well, my friend was trying to sell it.
Well, I bet. Yeah. I would love to have a court appointed lawyer too and not have to spend my own money and just taxpayer money. I mean, I would love to do that too. But
If it's possible, and I got some money in my bank account, it's just that they're not accessible because they're waiting for a new debit card to come in, be able to access that. And then I have the money then, that's be after the first.
be after the 1st of October, like next week.
Yes, yes, sir.
All right, this is what we're gonna do, Mr. Harris. I'm gonna set you for October 14th. You're just gonna end up sitting in jail if you don't get an attorney. So you need to take care of your business. And I know it's more difficult when you're in jail, but that's not my fault. You understand?
Yes, sir.
All right, we'll see you back on October 14th. Hopefully with an attorney.
Okay, Mr. Ashmore and Mr. Fredericks.
All right, do we have the paperwork ready?
We have it ready.
Yes, sir.
All right, is it gonna be, what's gonna be it's gonna be 2 years. Is it state jail TDC based on the state jail felony PCS lesson 1?
Yes, Judge.
All right, and so any credit time?
2 days, Judge.
Fine.
Fine is $2,500. Restitution, $180. Court costs $290. Reimbursement fees of $35.
Judge, I believe there's also 2 enhancement paragraphs. So it will be 2 TDCJ, institutional vision, not state jail. I think I may have misheard that, but I just want to clarify.
So it's state enhanced to a 3rd degree
Yes, Judge.
by
2 prior state jail
prior-
convictions. Yes, Judge.
And so do we have pleas of true on each of the enhancements on the judgment?
Yes, Judge.
All right, Mr. Fredericks, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Fredericks, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
And you've heard Mr. Ashmore read to me the plea agreement in this case, in which you're going to plead guilty to the charge of possession of a controlled substance in penalty group 1 less than 1 gram, state jail felony, and then the state has alleged 2 prior convictions, which my understanding is you're going to plead true to both of those, which enhances your punishment to a 3rd-degree felony, which has a range of punishment of 2 years, not less than 2 years, or more than 10 years, and a fine not to exceed $10,000. And you've heard Mr. Ashmore also read the plea agreement that you'd be pleading guilty on that charge in exchange for the state's recommendation of 2 years confinement in the institutional division of TDC, along with your credit, fine, restitution, court costs, and reimbursement. Is that right?
Yes, sir.
All right, Mr. Ashmore, do you believe Mr. Fredericks in today?
Fredericks.
Do you believe him to be competent today?
I do, Judge, and specifically I asked him because there was the issue at the courthouse about a positive test for methamphetamine and marijuana, which I was not aware of. And he has affirmed that he is not feeling the effects of either of those. And I do believe that he is competent and understands what's going on today. I've specifically asked him that.
All right, thank you, Mr. Ashmore. All right, Mr. Fredericks, understanding the range of punishment and the plea agreement in this case, how do you plead to that offense?
Guilty.
Are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
And with regards to the enhancement paragraphs alleged in the indictments, are those enhancement paragraphs true or not true?
True.
And are you telling me that those are true because in fact, the prior enhancements are true?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty or true to any of the allegations today?
No, sir.
All right, the court will accept the defendant's plea of guilt and also plea of true. Mr. Ashmore, any objection to State's Exhibit 1, the stipulation of evidence?
No, Your Honor.
All right, court admits State's Exhibit 1 and takes judicial notice of the defendant's guilty and plea of true. Anything further from the state?
Judge, I would just mention, I believe it's in the judgment, the state is also taking into consideration 2 unfiled cases, a DA control number 2020-1170, which is possession of controlled substance penalty group 3 less than 28 grams, and DA 2020-1171, which is a tampering or fabricating with physical evidence charge as well with the completion of this plea.
And that's confirmed they are on the judgment, Your Honor.
All right. And Mr. Woodwhite, can you go ahead and give me the facts to support the plea?
Yes, Judge. On November 29th of 2020, the defendant is pulled over by Canton Police Department for driving in the left lane while not passing. While the defendant is coming to a stop, the CPD officers see what they believe to be a bag fly out of the window. One approaches the defendant, the other goes and finds the bag and sees what they believe to be methamphetamine inside. While speaking to him, defendant admits that he threw the bag out the window because he was scared. Lab confirms it's 0.65 grams of meth inside.
Thank you, Mr. Woodwhite. Mr. Ashmore, any objection to that summary?
No, Your Honor.
All right, then anything further from the defense, Mr. Ashmore?
No, Your Honor.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict the defendant of the offense. Court will follow the plea agreement in this case. The court convicts Mr. Jacob Dwayne Fredericks of possession of a controlled substance, penalty group 1, less than 1 gram, a 3rd-degree felony offense. Court finds the enhancement paragraphs to be true. Court assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. Court awards him 2 days credit towards that sentence for time already served. Court orders him to pay a fine of $2,500, restitution of $180, court cost of $290, and reimbursement fee of $35. Court also takes into consideration under section 1245 DA 2020-1170 and DA 2020-1171. Mr. Fredericks, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are discharged from TDC or placed on parole, I'm going to order you to report back to the Van Zandt County Courthouse so you can make arrangements to pay the fines and court costs and other fees that you owe. Failure to try to pay that out, even through a payment plan, will result in the issuance of a warrant. You understand?
Yes, sir.
All right, good luck to you, sir. Go over with the bailiff to be fingerprinted. Hillary, tell Miss Abney I appreciate her. I don't know if she's listening. Tell her I appreciate her getting the paperwork done today.
Sure will. Thanks, Judge.
Okay, it's just gonna be a few minutes.
Yes, ma'am.
Judge, this is Eric Massey. That is Mitch Adams's defendant.
All right. Good afternoon, Mr. Massey. How are you, sir?
Very cool.
All right, Mr. Massey, I've appointed an attorney to represent you. His name is Mr. Mitch Adams. Have you met with Mr. Adams before?
I have not. A pleasure.
Okay, well, Mr. Adams is not able to be here today. He's in another court, but he's going to come by and see you soon to discuss your case. And I wanted to let you know that the reason we weren't having a hearing today is because he's not available, but he will be here as soon as he can on another day. And we're gonna bring you back to court on October 14th to talk to you about your case. Okay.
Okay.
All right. Do you have any questions?
No, sir.
Okay. All right. We'll see you back on the 14th, and we'll let Mr. Adams know where you're at so he can come see you.
Thank you.
You're very welcome, sir.
We'll see you back on the 14th at 1:30. Okay.
Thank you.
Oh, is that yours? I'm sorry about that.
Judge, can I ask you a question?
Hold on. Play Uno with that.
I think Mr. Lloyd Harrelson is going to be appearing by Zoom. That's what he told Ms. Barker. Do you see him on there?
He's not here.
Okay, so I'm not gonna bring Mr. Offit up until we know that he's present.
Okay.
And we're waiting on Mr. Stevens to get here. We're waiting on Mr. St. Julian's defendant to get here. And then Mr. Sanders is going over the plea papers with Mr. Amador. Do you want me to go ahead and bring up that Quentin Stanberry that you were gonna talk to?
Yeah, we'll go ahead and do that. Is Mr. St. Julian there?
He's out in the lobby waiting on Mr. East.
Okay, okay. Yeah, go ahead and bring up Mr. Stanberry and we'll talk with him.
Okay.
All right, thank you.
Okay, Judge Martin, this is Mr. Quentin Stanberry.
Mr. Stanberry, how are you today, sir?
Good, how are you?
I'm doing fine. I wanted to talk to you about an issue on your bond, okay? So I think your bail amount is about $20,000 on your charge. And what I was wondering is, Mr. Stanberry, is if I put a condition on your bond for you to go to the Glen Oaks Hospital and to participate in their program, if I were to do that, I think that there may be a willingness in your family to help you and to post your bond. But my concern is that if I do that and you don't want to go, or you don't want to participate and you don't want to cooperate, then I don't want to take that opportunity away from someone else who could go and receive the benefit of that. Have you ever been to Glen Oaks before?
No, I talked to my family about it. I told them that I agree to go, like her bond me out. I go home, shower and get stuff, and she take like me some clothes and she take me there. And I agreed to do it. She said, just talk to you or whoever when they call me in here. And I told her I agreed to do it because I've been talking to her about it and going and getting some medicine to help on it. So that's all, really. I mean, I agree to do it and go do whatever needs to be done.
Okay. When you were not at Glen Oaks Hospital, where would you be living and staying?
I'm gonna stay with my grandma in the Canton of new apartments on 859 with her and her husband. I got my own room. Just live there because me and my mom, we don't get along really. So I'm gonna stay there and then go to this Green Oaks, and when I get out, go back to start working again. Do whatever.
What kind of work do you do?
I'm in the oil field.
Okay. All right. So what I'm going to do, Mr. Stanberry, I'm going to amend your conditions of bond, and I'm going to put that you enter and successfully complete whatever program Glen Oaks has for you. And so I will send that information to the pretrial release department, and they'll relay that information to your grandparents. Okay.
So that means I can bond out, right?
Well, you can bond out now anytime you want. I believe that your grandparents are willing to help you and
Yes,
they'll bond you out if you do this as a condition. And I'm willing to put this condition on based on you telling me that you're going to be a man of your word and you're going to go and do what you're supposed to do and enter into that program.
Yes, sir. I will do it for you.
Okay. All right. Well, I'm going to expect you to keep your word. Okay.
I will. And yes, sir, I will.
Okay. I'll get that done today, and we'll send message and word to your grandparents. Okay.
Will she know today or what?
She'll know today.
Okay. Thank you so much.
Hey, you're very welcome. Good luck to you, sir.
You too. Thank you.
Okay, Judge Martin, Mr. St. Julian is ready on Adrian East.
All right, this is cause number CR 2244, State versus Adrian Ladon East. And are we doing a plea today, Mr. St. Julian?
That is correct, Judge.
All right, and who has the paperwork with them that can tell me the terms? Do you have that, Mr. St. Julian?
I do, Judge. It's 9 years TDC, $3,000 fine, $180 of restitution.
9 years TDC, and is it to the indicted charge of second degree possession of controlled substance, 4 to 2?
That is correct. Actually, Judge, there's an enhancement paragraph. So, well, it's a second degree, but he's looking at the first degree punishment range.
Okay, so it is a first degree
Correct.
based on the enhancement. Okay, and can you tell me court cost $200?
I don't know if the court costs
It'll be on that judgment, very first page, halfway down the middle.
halfway down the middle. Court costs, fines are restitution. Court costs are $290, Judge.
Any reimbursement fees on there? Same area?
Just has the restitution, no reimbursement. No way.
$35.
35, Judge.
35, okay. And any credit towards that sentence?
He has 3 days.
3 days, okay. And are any other cases being taken into consideration?
No, Judge, this is the only one he has. pending.
This is the only one, okay. All right, Mr. East, if you will, sir, raise your right hand. I want to place you under oath. Mr. East, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. Your name is Adrian Ladon East, is that correct?
Yes, sir.
And Mr. East, are you a United States citizen?
Yes, yes, I was born in Berlin, but I have my paperwork and everything.
So you are a citizen?
Yes, sir.
Okay. And do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental disorder?
Yes, sir.
And what have you been diagnosed with?
Bipolar.
And are you currently undergoing treatment or on medication for bipolar?
No, sir, that was over 12 years ago when I went to TDC the first time. They did that.
Okay.
I didn't follow with it because it's not true.
Okay. So you don't feel like you need to be on medication today?
Not that kind of medicine, not bipolar medicine, no, sir.
Okay. Do you feel like you have a rational understanding of the proceedings and what's going on in this case?
A little bit, but my lawyer explained it to me, so yes, sir. Yes, sir.
Okay. Well, speaking of your attorney, Mr. Grant St. Julian is your attorney. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
I mean, I'm still confused, but yes, sir, because I'm not into this. I don't know nothing about this, but I have a grasp. Yes, sir.
Tell me what it is that you're unclear about.
Just the whole situation. I know I did wrong, but just the sentencing and.
Judge, if I could, let me arraign him. I'll tell you what, we've talked to him. I don't think he's confused about the process, but it's just this being Judgment Day. Now, Mr. East, you understand what you're charged with.
Yes, yes.
You understand the punishment range is 5 years to 99 years in the penitentiary.
Yes, sir.
We talked over that. You know, you have a right to have a trial.
Yes.
You do not have to take this plea bargain.
Yes, sir.
And you understand if you go to trial and you're found not guilty, you're dismissed, you have no obligation.
Yes.
You understand if you're found guilty, either the court or the jury could put you in jail from 5 to 99 years. You understand that? If you're found guilty, and I'm not saying they are. All right, you understand that you understand the plea bargain. The plea bargain is you've got to give up your right to trial and you're accepting the certainty of 9 years in the penitentiary. You understand that? Now, is that how you want to resolve your case?
No.
You do not want to resolve your case that way.
Well, yes, I do.
Okay, you want to accept the plea bargain
Yes,
as it is.
yes.
You understand you're waiving your right to trial, and this is the finality. You'll be sentenced to 9 years.
Yes.
Do you have any questions of me or the prosecutor or the judge about what's going on today?
No, no.
All right. So Mr. East, thank you, Mr. St. Julian. So Mr. East, you feel like you have a firm grasp of what's going on in your case now?
Yes, sir.
Okay. And Mr. St. Julian, do you believe Mr. East to be competent today?
I do, Your Honor.
And you've represented him for quite some time. Have you seen any kind of signs of bipolar or any other mental health disorder that would give you concern?
No, Judge, he's had some medical issues due to COVID. He's got diabetes, but he does not have any medical issues that I've been able to detect.
Thank you, sir. All right. So Mr. East, you are charged by indictment with the offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams, which is normally a second-degree felony offense with a 2 to 20 sentencing range. However, there has been an enhancement paragraph alleged in your case regarding your prior conviction, which, if proven true, would enhance your punishment range to a first degree, which is a minimum of 5 years to a maximum of 99 years or life. The same thing that Mr. St. Julian said. Do you understand that full range of punishment?
Yes, sir.
And you heard Mr. St. Julian read to me the plea agreement in this case. Is that what you're asking the court to approve today?
Yes, sir.
Okay. All right. So, Mr. East, at this time, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams? Guilty or not guilty?
Guilty.
All right. And Mr. East, regarding the enhancement paragraph in the indictment alleging a prior conviction, is that enhancement paragraph true or not true?
It's true.
And Mr. East, are you pleading guilty because you are guilty of committing that offense? And are you pleading true because the allegation is true?
I'm pleading guilty because I am guilty, sir.
Okay. And your prior conviction is true?
Yes, sir.
All right. And so Mr. East has any question?
No, you've been in the penitentiary.
Oh, yes. Oh,
Yes.
yes.
Any
Yes, sir.
questions?
Yes, sir.
Okay. So Mr. East, has anyone pressured you to plead guilty or plead true today?
No, sir.
Are you making this decision because this is the decision that you want to make based on the information that you have?
That too, yes, sir. And I need to change. Yes, sir.
Okay. All right. Then the court will accept the defendant's plea of guilt and the plea of true at this time. Mr. St. Julian, any objection to State's Exhibit 1, the stipulation of evidence?
No, Your Honor.
All right. State's Exhibit 1 is admitted and the court does take judicial notice of the plea of guilt and the plea of true. State, anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Ms. Heiser, can you give me the facts to support the plea?
Yes, Your Honor. Canton PD stopped Mr. East's vehicle for a defective tail lamp. Immediately upon approaching, the officer could smell both the odor of marijuana and alcohol. Mr. East was asked about the odor. He admitted to smoking earlier in the vehicle, but said that there was nothing remaining in the vehicle. The officer explained to him that based on that, he would have probable cause to search, asked him to step out. And when he does, he sees in the floorboard a baggie that contains both marijuana and ecstasy. The ecstasy field weighs 42.35 grams. It goes to the lab. They test 9 of the 24 pills collected, and that returns 9 pills returns as 6.09 grams of meth. As is common, that ecstasy did come back testing positive for meth, as we're used to, Judge. So that's Mr. East also admits that all of the drug paraphernalia and drugs in the car belong to him.
Thank you, Ms. Heiser. Mr. St. Julian, any objection to that summary?
No, Judge, that is accurate, was on the video.
Thank you. All right, Mr. East, and based on the evidence as it's been presented, the court finds that there is enough evidence to convict you of this offense. The court will follow the plea agreement that you've reached with the state. The court hereby finds you guilty of possession of controlled substance, penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court finds the enhancement paragraph to be true, increasing your punishment range to that of a first-degree felony. In accordance with the plea agreement, the court assesses your punishment at 9 years confinement in the in the institutional division of the Texas Department of Criminal Justice. Court assesses a $3,000 fine, orders you to pay $180 restitution, $290 court cost, $35 reimbursement fee, and the court awards you 3 days credit towards that sentence for time that you have previously served on this case. Mr. East, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir.
Thank you. Thank you, Judge.
Thank you, Mr. St. Julian.
Thank you, Judge. May we be excused?
Yes, sir.
Okay, Judge, Mr. Sanders is ready on the plea on Mr. Amador.
Okay. All right, this is cause numbers CR 21-204 and CR 21-205, State versus Daniel Horton Amador. And are we pleading on both cases or just one?
Your Honor, it's pleading to CR 21-00205, aggravated assault.
All right, and will the unlawful possession of firearm be taken into consideration?
Yes, Your Honor.
All right, and Mr. Sanders, can you give me the term?
Yes, it's 10 years since TDCJ, probated for 10 years, fine of $3,500, 1245 CR 21-00204, and then court costs.
$290 court cost?
Yes, $290 in court costs, and then reimbursement fees of $920.
So 10 pro 10, 3,500 fine, 290 court cost, 920 reimbursement. And then 1245 the firearm.
Yes, that's correct.
All right, Mr. Amador, if you'll raise your right hand, sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, it is.
All right, you may put your hand down. Mr. Amador, are you a United States citizen?
Yes, sir, I am.
Do you read, write, and speak English?
Yes, sir, I do.
Have you ever been diagnosed with a mental condition?
No, sir, I don't.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation?
Yes, very pleased.
Do you feel like you've had enough time to discuss your cases with him and have all your questions answered?
Yes, sir, I do.
Is there anything in this paperwork that you've read and signed that you do not understand?
No, sir, you made everything perfectly clear.
All right, Mr. Sanders, do you believe Mr. Amador to be competent today?
Yes, sir, I believe he is.
And you've explained to him his legal and constitutional rights, and do you believe that he understands them?
Yes, sir, I believe he does.
All right, and you've gone over the conditions of community supervision, and he knows what's expected of him?
Yes, sir, he does.
And he knows the consequences of violating the terms of his community supervision?
Yes, he understands if he violates, he can be revoked and sentenced up to 10 years. And also understands with it being aggravated that you have to serve at least half of that time.
All right, Mr. Amador, you are charged by indictment with aggravated assault with a deadly weapon, a second-degree felony offense, carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. As you've heard, the plea agreement in this case, the sentence would be on your plea agreement would be 10 years in TDC, with that being suspended and you being placed on community supervision for a period of 10 years, along with your fine, court costs, reimbursement fees. I find that that fits within that legal range of punishment. So understanding the range of punishment, understanding that what your plea agreement is, do you want to go forward with your plea in this case?
Yes, sir.
All right, so let me ask you, Mr. Amador, how do you plead to aggravated assault with a deadly weapon?
Guilty. Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Sanders, any objection to states one?
No objection.
All right, states one is admitted in evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. State would like to put on the record that we do have an affidavit of non-prosecution in this cause from Mr. Amador's father, who is the victim. Frankly, Judge, I was not comfortable with probation for this charge. However, after speaking with the victim and his wishes, the state is going to defer to his wishes as stated, both in the A&P and his discussions with our coordinator. We don't have a victim impact statement on file. However, we've had several discussions with him about the outcome of this case.
All right, thank you. Go ahead and give me the facts to support the plea.
Yes, Your Honor. Mr. Amador's father called 911 stating that he had come home and he had not stopped by the ATM on his way home from work, as he and his son had discussed, to pick up money. They get in a verbal altercation over that money or the lack thereof. And at that time, Mr. Amador pulls out a knife and attempts to stab his father in the neck. His father is able to get his hand as a block, is stabbed multiple times in the hand, is able to get away, lock himself in a vehicle and call 911. When 911 or when emergency responders get there, they find the father, they confirm through the blood trail, his story. And then they speak to Mr. Amador, who basically says, I didn't really mean to stab my dad, but I did have a knife and we were in an argument. Like I said, the father has already filed an A&P in this cause.
Thank you, Ms. Adams. Mr. Sanders, any objection to that summary?
No, Your Honor.
All right, then based on the evidence, the court will follow the plea agreement in this case. The court hereby convicts Daniel Amador of aggravated assault with a deadly weapon. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place Mr. Amador on 10 years community supervision. Order him to pay a $3,500 fine, $290 court cost, and $920 in reimbursement. Court will take into consideration under section 1245, CR 21-204, unlawful possession of firearm by felon. Mr. Amador, I want you to understand that if you violate your conditions of community supervision and the state here is forced to file a motion to bring you back before the court, if we find that to be true, if the court finds that to be true, then you're going to be sentenced to 10 years in prison.
Yes, sir. You have a problem on me.
I want you to be thinking about that as you may be thinking about making a decision that would be a violation. You understand?
I understand.
All right. You're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff to be fingerprinted. The probation department will give you further instructions.
Thank you, sir. God bless you.
You're welcome. Abney, thank you very much for getting Mr. Amador's papers done today. I do appreciate you. All right, so it looks like we're waiting on Mr. Stevens, and he indicated that it would be late. And we're also waiting on Mr. Harrelson. I still do not see Mr. Harrelson online.
Okay, Mr. Stevens is here and we're fixing to bring his 3 in.
Okay. Are any of Mr. Stevens going to be a plea that you are aware of, State?
No, sir.
let's do James. Yes, let's do him first.
Derringer, I'm sorry. I do it every time.
All right, this is CR 21-163, State versus James Michael Derringer.
Yes,
Set for trial, Mr. Stevens.
Yes, sir. We're set for pretrial. We have no formal pretrial matters, Your Honor.
All right, there being no formal pretrial, the court will set Mr. Derringer for docket call on October 26th. I believe that's when I set you earlier this morning. Is that right, Mr. Stevens?
Yes, sir. You did at 9 o'clock.
Okay, so this will be at 1:30. If Mr. Derringer makes bail, then his cases will be called in the courtroom at 9 a.m.
Judge, next we're gonna do Steve Simmons. Can you bring his indictment up and share your screen?
I'm already ahead of you. That's what I was working on.
Thank you.
For once, I was ahead of you,
No,
but don't get used to it.
okay.
Judge, I apologize for not having the indictment when I went to see my client. Oh, there we go. That's it. Right. Okay. Judge, we're good. We're good with it, Judge.
Okay,
I had actually gone to see him in jail, I think, week before last, and given him my copy of the indictment. So that's why I didn't have it with me today.
okay. This is cause number CR 2365, State versus Steve Leonard Simmons, and we're set for arraignment.
Yes, if it may please the court, Your Honor, my client would advise he understands the nature and the consequences of the charge. We will waive reading of the indictment and enter a plea of not guilty.
All right, court will enter Mr. Simmons' plea of not guilty into the record. We'll set this matter for pretrial. Any objection to October 26th, Mr. Stevens?
No, sir. No, sir.
All right. That'll be at 1:30. If Mr. Simmons makes bail in this case, then all hearings will be called at 9 a.m.
Thank you. And we're ready on Mr. Rice, Your Honor. It's set for sentencing.
Yeah, I'm not sure why. I thought we set this on the 30th. I was looking at the notice of appearance. It
No.
says it's on the 30th.
Judge, I thought it was set on the 30th also, but when I got my docket, I noticed it was today. But I also thought I had it on my calendar for the 30th. But
Well, I went back and looked at your docket and it said the 28th, so I put it on the 28th, but I did notice that the reset had the 30th.
Okay, that's probably just my mistake. All right, I'll tell you what, let me step off and go get my notes that I left because I was anticipating it would be on the 30th. So let me step off the bench and go get my notes and I'll be back. Just, are we still wanting to go forward with the court on sentencing? Y'all haven't reached an agreement or anything, is that right?
no, sir, we've not reached an agreement. No, sir.
Okay, give me just one moment.
Yes, sir. Thank you, Judge.
All right, we ready to proceed?
Yes, Your Honor.
All right, if we can have Mr. Stevens, Mr. Rice. All right, this is cause number CR 2407, State versus Abram Hastings Rice. Court finds for the record that Mr. Rice appeared before the court on August 26, 2021. And it's my recollection that he pled. Did he plead not true, Mr. Stevens?
That's correct.
Right. He pled not true to counts 1 and 2 of the state's motion to adjudicate and revoke, which was filed in the court on April 15, 2021. Court recalls that it received evidence that day, and the court, based on the evidence, hereby finds that Abram Hastings Rice III has violated the terms and conditions of his community supervision. Court finds counts 1 and count 2 in the state's motion to be true. And at this time, what I think I want, just as a refresher from counsel, is a summary of the request from the defense and from the state. Go ahead, state.
Thank you, Judge. Sorry, I couldn't get my mute button off. Judge, if I recall correctly, the state's position was that Mr. Rice very recently to the new offenses alleged was placed on deferred adjudication. At that time, the court gave him a speech, and I believe that the state gave him a speech at that time, that he was receiving deferred on a very serious charge wherein his mother ended up being suffering from a gunshot wound because of his actions. And we explained to him in no uncertain terms that deferred meant that the full range of punishment would be open, and that should he come back before the court, that the seriousness of the charge would be requested by the state. And due to the lack of length, for lack of a better way to say it, the shortness of the period in which he was able to remain on probation without committing a new violent offense against the same victim gives us concern. Clearly, the threat of 20 years in prison was not sufficient enough to curb his behavior, change his behavior to where that victim did not feel like she was in danger from Mr. Rice. So we asked the court to enforce the full power of the 20-year sentence given under the deferred option.
Thank you, Ms. Heisel. Mr. Stevens.
Yes, Your Honor. We were asking for Mr. Rice to be continued on probation, or in the alternative, revoke the probation, revoke his deferred, and put him on a new adjudicated probation. That's what we were asking for. Judge, the basis for our request is basically he lives with his mom, who's 84, I believe, or 84 on Friday, Judge. And she has very poor health. There is no one to help take care of her except Mr. Rice. There was a brother living at the house, there's a lot of conflict between the two brothers. It's my understanding he's no longer in the home. He's actually locked up, has a hold on him, a blue warrant, so he'll be headed to TDC before long. Mr. Rice has a sister who I spoke with the sister, but she lives up in the Dallas area. I forgot exactly where. Fort Worth area, Judge. And she's unable to come down and to care for her mom other than just a day here and a day there. So really there was no one to care for this lady. We were going to try to have her testify, but she didn't have the capability to get on Zoom. And her daughter, Mr. Rice's sister, had gone back to Fort Worth the day before we had our hearing. So we weren't able to bring Miss Rice either to court or on the hearing via Zoom. So with that being said, Judge, we respectfully ask that Mr. Rice either be reinstated, adjudicated, adjudicating guilty, put him under new probation. That's what we're asking for, Your Honor. And Mr. Rice by no means plays down the fact that he violated his probation. I think it's clear he pled not true, but it's clear he violated his probation. I don't think there's really any argument there, Judge. We're just asking for leniency from the court to give him another chance, Judge.
Thank you, Mr. Stevens. All right, based on the evidence and arguments of counsel, the court, having found that counts 1 and 2 are true, the court hereby adjudicates the guilt of Abram Hastings Rice III for aggravated assault with a deadly weapon, second-degree felony. The court hereby revokes his community supervision on the basis of that finding and assesses his sentence at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. And the court orders him to pay the balance of his financial obligations. Mr. Rice, you will be given credit for any time that you have spent in jail on this cause. And the judgment will be produced and we will have it delivered to the sheriff's office, and a fingerprint will be gotten from you, and we'll leave you with a copy of that judgment. Mr. Rice, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir. And state if you'll have Ms. Abney produce that judgment tomorrow, it's fine, and then we'll have the jail go out and get that fingerprint for us.
Thank you, Judge.
Thank you, Judge.
And let me say, and I believe, I think I also need to announce that the court does make an affirmative finding that a deadly weapon was used on the underlying offense.
Your Honor, what about the 2 misdemeanor charges that were the basis of the motion to revoke? Is he going, are those going to be pursued or dropped?
Let me find out from the state.
Thank you, Judge.
Judge, state will tender motions to dismiss on those downstairs based on the sentencing in today's hearing.
Thank you, Ms. Heisel.
Thank you, Judge.
All right. Thank you, Mr. Stevens. Yes, sir.
Thank you.
Your Honor, I would like to fire my attorney and hire an attorney.
You can hire an attorney and you can appeal your sentence.
Okay.
And so that you understand, you have a appellate deadline. You've got 30 days to file a motion, other appellate things, but you understand that as a part of your plea agreement, you waived your right to appeal, but you can appeal the sentencing, I believe, in today's hearing.
That's right. I understand that.
All right, but you do have the right to hire an attorney.
Okay. All right. Thank you.
You're welcome.
Good luck, Mr. Rice.
Ms. Abraham, is that everyone?
Well, we still have a Tanner Offit and Lloyd Harrelson.
Not seeing Mr. Harrelson at any point today. All right, so this is what we're going to do. We're going to set Mr. Offit for, is he in the room there?
He's in the gym. I mean, I can get him in here.
Yeah, that's fine. Let's do that. Bring him in.
It may take a minute. They're trying to deal with Mr. Rice.
I can imagine so.
Okay, Judge, here's Tanner Offit.
All right, this is cause number CR 18329, State versus Tanner Offit. Mr. Offit, your attorney, Mr. Harrelson, did not make an appearance today. He didn't appear on Zoom. He not contacted us. Don't know where he's at. So what I'm going to do is I'm going to reset your case for a contested hearing on October 28th. If you and Mr. Harrelson can somehow reach an agreement with the state that resolves your case before then your attorney or the state's attorney will contact me and we can get it scheduled quicker than the 28th. Otherwise, we're going to come back on the 28th and we're going to have a hearing and the court will decide whether your probation's reinstated or if you're revoked and sentenced. You understand? So I think it's very important when you get back to make a call to your attorney. I'm assuming that you paid Mr. Harrelson?
Yes, sir. Yeah, I was aware. He told my wife yesterday he would be here, so I don't know what transpired.
Yeah, so yeah, find out. I'm assuming that you expected him to be here, but he's not. So I'm gonna call him and hold his hand and try to chase him down. So
Yes, sir.
I'll let you take that issue up with him.
All right. Thank you, Your Honor.
Thanks, sir.
Judge, I think that completes our business.
May I be excused?
Can we be excused?
Ditto.
Y'all can excuse me. I will excuse you.
Okay.
There is no excuse for us, Judge. I just like to put that out there.